Hello dear aspirants, welcome to Epitome IAS. So dear students, we are doing the UPSC PYQ analysis series and today's topic would be the continuation of judiciary from the Indian polity, and we'll be completing this particular topic in today's video. Okay, so let us start with the first question. The salaries and allowances of the judges of High Court are charged from the Consolidated Fund of India, Consolidated Fund of State, Contingency Fund of India, Contingency Fund of State. Okay, if you see here, obviously the Supreme Court's charges are charged upon the Consolidated Fund of India. We know that. But here where they are asking the salaries and allowances of the judges of high courts. So technically these high courts come under they cover the jurisdiction of the states, right? So technically they are taking care by the state finance. Okay, taken care by the state finance. So technically the state consolidated fund of a state is responsible for providing the salaries and allowances of the judges of the high court. Okay, so what we can say here, the salaries, the allowances of judges of high court are charged from the consolidated fund of the state. Okay, and in case of Supreme Court, we know that from the Consolidated Fund of India. Now tell me, these are for serving judges, the judges who are actually serving. What about the retired judges of High Court? Let us say there is a judge of High Court. So once he got retired, the pension, okay, should be paid from Consolidated Fund of India or Consolidated Fund of a state. Tell me, of a High Court judge. So the answer is it is charged from the Consolidated Fund of India. So once the High Court judge he got retired and he is getting pension, these pensions are taken out from the Consolidated Fund of India. Okay, while he was serving, the salary and allowances, okay, will be coming from the Consolidated Fund of the state. Okay, so we got the answer. So Indian financial system. So first of all, you need to understand the Indian financial system is kind of federal in nature. You know that, right? The central government, state government, they have separate resources, they have separate revenue, they have separate expenditure. Okay, so if you see here, India follows a federal system where the financial resources are divided between central government and the state government. Okay, each has its own designated funds for managing the expenses. For example, we have Consolidated Fund of India. This fund receives all revenues collected by the central government. So whatever revenue the central government is collecting, this directly goes to the Consolidated Fund of India. Revenues kahan se, like where did the revenues come from? Revenues come from taxes, duties and other sources. You will be reading it detail in economy, right? So these revenues collected by the central government directly goes into the Consolidated Fund of India. Okay, the central government uses this fund to meet its own expenses. Now what happens once it will be collecting the revenue, putting in the Consolidated Fund of India? Now the central government also has expenses, right? It has to pay its government servants, it has to pay other people who are working for the government, and it also has other expenses, right? So for these expenses it will be using these fund which are already collected in the Consolidated Fund of India. Okay, so the central government uses this fund to meet its expenditure, including those of national agency and institutions. Okay, then we have Consolidated Fund of State. Just like in national level, we have Consolidated Fund of India. In state level, each state have separate Consolidated Fund of a state. Okay, what this do? Obviously, the revenues of the states are collected and they are deposited in the consolidated fund of the state, and the state governments also have expenditure, right? So these expenditure, they'll be using the fund for these expenses by the state government. Okay, so the consolidated fund of the state is similar to the central government's consolidated fund of India. This fund receives revenue collected by the state government from various sources. What are the sources? Like tax, duties, fees, etc. Okay, all these revenues are collected and deposited in the consolidated fund of the state. Okay, the state government uses this fund to finance its various expenses. It has some, let's say, different departments are there, different let's say for paying the servants, government servants, state government servants, and let's say it also has some of the social programs. Okay, for these programs also it comes under the expenditure of the state government. So all these expenses are paid from the consolidated fund of the state. So now in this only consolidated fund of the state only, the high court judges, the salaries and allowances of high court judges are paid out of consolidated fund of a state. Why? Because these high courts are specifically designated to particular state. Okay, so that's why they are actually taken care by the state government or the state fund, not the national fund. Okay, then high courts are the principal courts in each state within few exceptions. Obviously, not all states have high courts. Only there are few exceptions. We already saw, right? Three high courts are actually sharing the jurisdiction with different states. Okay, not all high courts are have all states are having high courts of their own. Still, in theoretically, we can say each state, every state is having a high court. Okay, theoretically. In that case, this is a state level institution, right? It is taking care of the state's jurisdiction. So that's why this expenditure should be taken out from the state's consolidated fund. Okay, not the consolidated fund of India. Okay, so they handle the appeals of the lower courts. So what is the major function of the high court? To handle the appeals from the subordinate courts or the lower courts. This is one of the function of the high court within a state. Obviously, in one state these subordinate courts are there. Only these appeals can be handled by the high court, not from another state, right? So this particular state's subordinate courts are, since high courts primarily serve the state's judicial needs, the financial burden of their functioning falls on the state government. Okay, I already explained this. The salaries and allowances of the high court judges are considered as an operational expense at the state judiciary. Therefore, these expenses are funded from the consolidated fund of the state. Okay, then consider the following statements regarding the high courts in India. Now, this is an interesting question. We are seeing these type of question again and again. In previous video, in one of the other video also, we saw this type of questions, right? So the first statement is saying there are 18 high courts in India. Tell me whether this statement is correct or not correct. So you should be able to answer this correctly by now because you are continuously watching the video, right? So you have to tell whether this is correct or wrong. Okay, then second statement, three of them have jurisdiction over more than one state. Again, this also you should be able to tell because we discussed in it in previous videos, two videos, right? No union territory has a high court on its own. Again, you have to tell this also. We have discussed this also. Then judges of the high court hold office till the age of 62 years. Okay, this is a factual thing. Okay, now tell me the answer. You have to tell me the answer. Pause this video, try to answer this yourself. Okay, I'm telling the answer now. First statement says there are 18 high courts in India. Technically, this is wrong. We have 25 high courts in India. Currently, don't care about this. Question was asked in 2001, right? Don't think about what was like the number of high courts in 2001. No need to remember that. They are not going to ask that question. Just remember, currently there are 25 high courts in India. So this statement is a wrong statement. Second statement, 3 of them have jurisdiction over more than one state. Is that true? Yes, this is true. Only 3 high courts have jurisdiction over more than one states. We are talking about states now. We are not talking about the union territory. So when you are talking about the states, then only 3 high courts have the jurisdiction over, more than one state. Okay, what are these 3? Tell me, what are these 3? One is obviously the Punjab High Court, which shares the jurisdiction with Punjab, Haryana, and the Union Territory of Chandigarh. Now they are asking about the states only. So obviously Punjab and Haryana, these two are 2 states. So these, this 2 states are sharing a high court. So this is there. Then the second one would be, tell me what is the second one? Second one is Guwahati High Court. Guwahati High Court shares the jurisdiction over 4 states. Now tell me what are these 4 states? Tell me what are these 4 states? Then we have Bombay High Court. We have Bombay High Court, which shares jurisdiction over Maharashtra and Goa. Goa is also state, right? So Maharashtra and Goa, these 2 states, they share Bombay High Court. So these are the 3 high courts which are shared by the states. Okay, and there are 6 high courts which are actually shared by the union territories along with the states. So when they are talking about the states, there are 3 high courts. I have already discussed these 3. And when they are talking about union territory, 6 high courts are there. Okay, one is obviously the first one, because Punjab, Haryana, and Chandigarh. Chandigarh is a union territory. And second one is Bombay. Why? Because Bombay, it is also, sharing the jurisdiction of Dayu, Daman, Dadra Nagar Haveli. Okay, these are union territories, right? So along with these states, it is also covering the union territory. And the third one would be West Bengal, which let's say Calcutta, okay, Kolkata, the Calcutta High Court, which shades the jurisdiction over West Bengal, and the Andaman Nicobar. Andaman Nicobar is a union territory here. Then we have a Kerala High Court, and Kerala High Court, it shares the jurisdiction over Kerala and the Lakshadweep. Okay, this is what 3, 4, and then we have Tamil Nadu, that is the Madras High Court. So the Madras High Court, it shares the jurisdiction over Tamil Nadu and the Puducherry. Puducherry is a union territory. And then we have Jammu and Kashmir. It is a union territory. It shares the jurisdiction over Jammu and Kashmir and the Ladakh. So whenever they are saying that how many high courts share the jurisdiction over more than one state. More than one state, when they are talking about the states, the answer is 3. Okay, these 3. Punjab, Guwahati, Bombay. Okay, because they are sharing more than one state. Okay, in case of, Guwahati, Assam, Nagaland, Mizoram, and Arunachal Pradesh. Okay, so these 4 states. So these 3 are the high courts which are shared by more than one state. But whenever they are asking how many high courts in India, they are shared by, more than one state or union territory. If they are including a union territory, then the answer is 6. I told you what are the 6 examples. Okay, then this statement is a correct statement. Why? Only 3 of the high courts have the jurisdiction of more than one state. Here they are talking about only the state, not the union territory. Now, Third statement, no union territory has a high court of its own. Is that true? Yesterday we talked about this thing. Delhi, we have Delhi High Court, and Delhi is a union territory. It has a high court of its own. Then there is another union territory also which has its own high court. That is the Jammu and Kashmir. Jammu and Kashmir is a union territory, and Jammu and Kashmir has a own high court. That is the Jammu and Kashmir High Court. Okay, so this statement is a wrong statement. Then statement 4, judges of the High Court hold office till the age of 62 years. Yes, this is true. Factual question. You have to remember some of the factual numbers also. Sometimes years, numbers, articles. So this is one of the important. You have to remember, for High Court judge, they can hold the office up to 62 years. Tell me, what is the year? What is the age for Supreme Court judge? Okay, what is the maximum age for a Supreme Court judge to hold the office? So tell me that. And this is the correct answer. So this is gone, this is gone. Answer is 2 and 4. 2 and 4, option A is the correct answer. Okay, then here, if you want, let me just quickly recall how many high courts we have and how many high courts are shared by the states and union territory, because it was actually messier, right? So for those of you who want to take a copy, you can see this, or you can skip also, it's up to you. So first, we know we have Supreme Court, and we have High Court. Supreme Court at the national level and High Court at the state level. And total, we have 25 high courts in the country. Currently, 25 high courts. You have to remember this. And whenever they are asking about number of high courts which are shared by more than one state. Now they are talking only about the state, not about the union territory. So more than one state. So there are 3 such high courts. What are they? Punjab High Court. Punjab High Court. It is shared with Punjab. Then it is shared with Haryana. These two are what? These two are states. And it is also shared with the Union Territory of Chandigarh. Okay. So the jurisdiction of Punjab High Court. Then we have Guwahati High Court. Don't mind the spelling. Okay. Guwahati High Court. It is shared with 4 states. What are these 4 states? We have Mizoram. We have Arunachal Pradesh. Then we have Assam. Then we have Nagaland. So these are the 4 states, Guwahati High Court. Then third one would be, what is the third one? Third one is Bombay High Court. So Bombay High Court, obviously Maharashtra and Goa. So here 2 states, Maharashtra and Goa, it is shared by 2 states. Apart from that, it also has the jurisdiction over the union territories of Diu, Daman, then Dadra, Nagar Haveli. Okay, so these are the union territories. So these are the 3 high courts which share jurisdiction over more than one states. Now, when they are asking about how many high courts they share the jurisdiction over, states and union territories, more than one state or union territory. In that case, there are 6. The answer is 6. What are they? These 3, obviously. This one is not there, Guwahati High Court, because it is. This is also there because they are asking states and union territories, right? States and union territories, both are included. Okay, so this is also there. Then we have Kerala High Court. Kerala High Court shares jurisdiction over Kerala and Lakshadweep. Then we have Madras High Court over Tamil Nadu and Puducherry. Okay. Then we have Kolkata High Court over West Bengal and over Andaman and Nicobar. Okay. Apart from that, we have Delhi High Court. It is the only union territory which has a own high court but does not share the jurisdiction over any other high court or any other states. Okay. Then we have Jammu and Kashmir, which is a union territory sharing its jurisdiction with Ladakh. Ladakh is also union territory. So whenever they are asking one state plus any state or union territory, the answer would be 6, because here there is no state. Both are union territory. If they are asking one state or union territory plus another state or union territory, then answer would be 7. Okay. If they are talking only about the states, the answer would be 3. Okay. Just try to analyze this one time. Just take a screenshot if you want and try to analyze it. You will be understanding what I'm trying to say. Okay. Then next question. Supreme Court of India tenders advice to the President on a matter of law or fact. Option A, on its own initiative. Option B, only if he seeks such advice. Option C, only if the matter relates to the fundamental rights of the citizens. And option D, only if the issue poses a threat to the unity and integrity of the country. Again, you should be able to answer this question also. We have discussed this like n number of times. So try and tell me the answer. So whenever the Supreme Court of India, it tenders advice to the President of India. What is this? This is nothing but the advisory jurisdiction. Advisory jurisdiction of the Supreme Court. So this advisory jurisdiction, okay, this advice can be given only when the President seeks for the advice. The Supreme Court does not have the power to give advice on its own to the President of India. Okay, this advisory jurisdiction can only be exercised when the President asks for an advice. Okay, on any legal matter or any constitutional matter or any doubt which he has, in public interest, he can ask the Supreme Court, and then the Supreme Court will be giving those advice. The Supreme Court does not have the power to start this, process itself. It can't go and give the advice on its own. Okay, so the answer is option B, only if he seeks such advice. Okay, then this is advisory jurisdiction. Yesterday we saw this also comes under Article 143. Remember these numbers. Okay, Article 143, it talks about, or it provides for the advisory jurisdiction for the Supreme Court of India. Okay, this is a special power given to the Supreme Court of India by the Indian Constitution, and it allows the President to seek the court's opinion on any legal or factual matter which has a significant public welfare. Okay, then what is the key point which you have to remember here? The initiation. Only the President has the power to initiate this process. Okay, the Supreme Court does not have the power to initiate this process. Okay, then scope of question. So again, what are the scope or what are the areas where the President can ask the question? Ultimately, it doesn't mean only these areas he can ask question. He can ask in any topic. Okay, but these are some of the basic guideline to follow. These are some basic topics where he can ask the question, but he can ask question out of these topics also. There is no issue. So what are these topics? One, interpretation of constitution. When there is a confusion, when the President needs the certain provision of the constitution to be interpreted, he can ask advice from the Supreme Court of India, because Supreme Court of India, obviously, it has the legal expertise, right? Then legal validity of laws. Any law, what is the validity, legal validity? He can ask the doubt. Matter of international law, any international law related thing. Then policy decisions with significant implications. Okay, any policy decision taken by the government. Okay, what are the significant implications or the impacts of this policy decision? He can ask for advice from the Supreme Court of India. But here you have to remember one thing, like a very important thing. What is that? Whatever advice the Supreme Court of India gives, it is not binding on the President of India. Okay, it is just advisory in nature. The President can either accept those advice, or it can either reject those advice. Okay, there is no obligation that the President should accept these advice. Okay, so these advice given by the Supreme Court of India are only in advisory nature. It is not binding on the President of India. Okay, so the Supreme Court of India's opinion is purely advisory, and it is not, the President is not bound to follow the decisions. It's up to him whether to follow or not follow those advice. Okay, next question. The concept of public interest litigation originated in United Kingdom, Australia, United States, Canada. So the answer is United States. Okay, some of the major like liberal provisions or liberal thoughts, they actually are originated from the United States, USA. Okay, one such thing is public interest litigation. Okay, we already talked about public interest litigation in the previous video, right? So whenever there is let's say a group of people who are not able to defend themselves, who can't, let's say they are marginalized section of the society, they're poor people. Okay, they don't have awareness on legal matters, so they directly can't go to the court. Okay, but in that case, what can happen is another person who has a public interest who can help this person out, and he can file the case on behalf of this person. Okay, this is public interest litigation. Okay, and we already talked about this. Who are the pioneers of the introduction of public interest litigation in India? Earlier, it was not there, right? It was introduced by some of the famous people. Who are they? Tell me. One is P.N. Bhagavati, Chief Justice of India, and another one is V.R. Krishna Iyer. He was Justice of Supreme Court of India. Okay, so these two people are the pioneers in the introduction of public interest litigation in the Indian judiciary. Okay, then the concept of public interest litigation originated in the United States in 1960s, and when it was originated in India, or when it was introduced in India in 1980s. Okay, it emerged to address the needs for legal representation for previously unrepresented groups or interests such as poor, minorities, environmental protection, and consumer rights. These are some of the areas. Okay, then next question, assertion and reason. Okay, assertion: willful disobedience or non-compliance of court's order and use of derogatory language about the judicial behavior amounts to contempt of court. Okay, first of all, try to understand whether this statement is correct or wrong. Okay, let us go to the next statement later. So first, try to understand. Willful disobedience or non-compliance of a court, does that come under the contempt of court? Yes. Whenever someone is willfully is not, is disobedient to the court, or else we can say non-compliance of the, let's say the court is giving you some instruction to follow, then that person is not following it willfully, and non-compliance of the court's order, these both come under the contempt of court. Okay, apart from that, use of derogatory language to judges also. or any judicial process. Use of derogatory languages, these also comes under the contempt of court. This particular statement is a correct statement. Now let us go to the reason. Okay, judicial activism cannot be practiced without arming the judiciary with punitive powers to punish the contemptuous behavior. So now first of all there is a keyword here, that is judicial activism. First let us try to understand what is this judicial activism. Let us say in normal case what will happen, the judiciary is there, the judiciary will try to uphold the provisions of the constitution or any existing laws are there, it try to follow those procedures which are already mentioned in the laws. But what is judicial activism? Judicial activism is the judges or the judiciary taking a proactive step. Okay, it is not just following the existing laws, it is taking a proactive step and it is trying to bring in some changes, okay, which is not already done by the executive or the legislative. The judiciary is trying to initiate certain things by taking a proactive step. I'll give you an example, you'll try to you'll understand then. For example, we were talking about this public interest litigation, right? So in 1960s, obviously this public interest litigation was originated in USA. Just now we saw, I'm just giving you an example. And in 1980s only, this particular public interest litigation is started in India. Okay, it was not there in previous year. Before 1980s, there was no public interest litigation in India. It was introduced by the judges or the I told you, right, P.N. Bhagavati and V.R. Krishna here. So because of these proactive steps by the judges only, these provisions, this provision of public interest litigation has been introduced in the Indian context. Okay, so this is one example for judicial activism. I'll give you another example. There are many examples. I'll just give you some famous example which you already know. Okay, so in case of a Keshwananda Bharati case, you will be reading about it, right? It talks about the Supreme Court of India said the Parliament has the power to amend the Constitution of India, but it should not change the basic structure of the Constitution of India. So this basic structure doctrine was introduced in the Keshwananda Bharati case, right? This basic structure concept was not there before that. Okay, so what will happen? Let's say the Constitution of India is there. Okay, the Parliament has the power to amend the Constitution. Now the Parliament, what the Parliament will do? Parliament will literally amend whole of the Constitution and it will rewrite a new Constitution. है ना? So to prevent this or to make this happen, what can the Supreme Court do? The Supreme Court said in the Keshwananda Bharati case, the Parliament has the power to amend the Constitution of India. No doubt in that. But there are certain provisions which are considered as the basic structure of the Constitution of India. Okay, so the Parliament should not change the basic structure of the Constitution. Without changing the basic structure of the Constitution, the Parliament can amend the Constitution of India. These basic structure are like, let's say, pillars. Let's say there is a building, okay, and these basic structure are the pillars. Now this, let's say this building is the Constitution. Now the Parliament has the power to amend the Constitution, but it cannot change the basic structure of the Constitution of India. So this is what the Supreme Court said in the Keshwananda Bharati case. So technically, if you see, this basic structure concept was not existing before that. Only in this case, the Supreme Court of India, it introduced a new term, it introduced a new provision. Okay, so this is an example of judicial activism. The Supreme Court or the judiciary is not just following the existing laws. What it does, it proactively takes a step, okay, to prevent the government, the executive, the legislative, or the administration to misuse their power, to prevent it. Okay, so this is judicial activism. Now, we have discussed a lot about judicial activism. Let us go back to this question. So, what they are saying here is judicial activism cannot be practiced without arming the judiciary with punitive powers to punish contemptuous behavior. So let me explain you what they are saying in this particular statement. So they are saying, let us say, to practice judicial activism. I gave you two examples, right? So this is judicial activism. To practice this judicial activism, the judiciary should arm itself. It should, protect itself by maintaining punitive powers to punish the contemptuous behavior. Let's say someone is doing the contempt of court. When there is a contempt of court, the court should, take punitive action, punish them. Okay, and what this statement says here is only when having this punitive power or punishing these people, only when then the judicial activism can be followed. Is that true? Some cases, yes, punitive actions will obviously protect the judiciary, and it will help the judiciary to take a step, proactive step, judicial activism. Yes, this is there. But in the statement, what they're saying, it is only possible, the judicial activism is only possible when the judiciary is taking a punitive step, punishing everybody who is doing the contempt of court. Only when the judicial activism will take place. Is that true? No, not only then. Even without punishing or even without having the punitive power, the judiciary can exercise the judicial activism. So this statement is a wrong statement. Okay, yes, this punitive powers and punishing the contempt of court, it will help protect the judiciary and it will help in judicial activism, but it is not the only case. Okay, so this is a wrong statement. So we can directly go to the answer. R is false, A is true, option C is the correct answer. Okay, then next question. The power of Supreme Court of India to decide disputes between center and the state. I think this is one of the favorite question of UPSC. They keep on asking this same question. If you see, it's the same question. Try to answer this. A, advisory jurisdiction, B, appellate jurisdiction, C, original jurisdiction, and D, constitutional jurisdiction. They are asking that whenever there is a dispute between center and the state governments, this comes under the jurisdiction of Supreme Court of India. Okay, what is that? Advisory, appellate, original, constitutional. Tell me the answer. Answer is option C. It directly comes under the original jurisdiction of the Supreme Court. Okay, then see here. Indian Constitution empowers the Supreme Court with three types of jurisdiction. You will be reading about the three types of jurisdiction. What are they? One is original jurisdiction, then we have appellate jurisdiction, then we have advisory jurisdiction. Okay, so advisory jurisdiction, just now we discussed, right? Whenever the president seeks for an advice, the Supreme Court will be rendering those advice. That is advisory jurisdiction. Simple. Then what is this? Original jurisdiction and appellate jurisdiction. Appellate jurisdiction is nothing but, let us say, these subordinate courts are there. Okay, whenever there is an appeal on the judgment of the subordinate court, it will go to the High Court. है ना? This is subordinate court. Whenever there is an appeal on the judgment of the subordinate court, it will go to the High Court. And now whenever there is an appeal on the judgment of the High Court, it will go to the Supreme Court. So the Supreme Court has the power of appellate jurisdiction over these judgments of subordinate courts. This is the appellate jurisdiction. Appellate jurisdiction is nothing but the Supreme Court has the authority to hear the appeals from the judgments passed by the subordinate courts, high courts or other subordinate courts. let's say the lower courts, okay, on various legal matters. This is appellate jurisdiction. These two are over. Now, the third one is original jurisdiction. Original jurisdiction, what is original jurisdiction? Original jurisdiction means whenever these type of cases, these type of disputes are happening, these directly come under the jurisdiction of the Supreme Court of India. There is no need that it will go to High Court or subordinate court. It will directly come to the Supreme Court of India. That is the original jurisdiction. Okay. So this allows the Supreme Court to directly hear and decide specific cases without them going to through the lower courts. Okay, it will directly come to the Supreme Court of India. So now let us talk about this original jurisdiction of the Supreme Court of India. This is actually mentioned in Article 131 of the Indian Constitution. So what and all comes under the original jurisdiction? One, when there is a dispute between the Union of India. Union of India matlab what is that? Union of India matlab the government of India. Okay, when there is a dispute between the government of India, for your understanding I'll write government of India versus one or more state. Okay, whenever there is a dispute between the central government and a state government or state governments, two or more state governments, so this will directly come under the original jurisdiction. Now, the second case is, let us say the government of India along with some state, one or more state, versus one or more state. In this case, let us say the government of India, the central government is supported by one or more states, and this government of India along with that states having dispute with some other states. Then also this is come under the jurisdiction of original jurisdiction of Supreme Court of India. Then there is another case, that is whenever there is a dispute between two or more states. Okay, when there is a dispute between two states, or when there is dispute between two or three states, when there is a dispute between three states, so then also these will directly come under the original jurisdiction of the Supreme Court of India. Then the fourth case would be for the enforcement of the fundamental right. Of fundamental right. That is, we'll be talking about Article 32 of the Indian Constitution, the writ jurisdiction. है ना? So these enforcement also, whenever there is a dispute or issue regarding the enforcement of the fundamental right, this will also come under the original jurisdiction of the Supreme Court of India. Okay. Then another case would be transferring of cases. Transferring cases from one high court to another high court. Okay, the Supreme Court has the power to transfer a case from high court of one state to another high court of another state. Okay, this also comes under the original jurisdiction of the Supreme Court of India. Apart from that, it also has the power to transfer the case. Let's say there is a case pending in the subordinate court of a state. This case can be transferred to the high court of another state also. This also comes under the original jurisdiction of the Supreme Court of India under Article 131 of the Indian Constitution. Remember the number. Okay, then when the Chief Justice of High Court acts in an administrative capacity, he is subject to A. the writ jurisdiction of any of other judges of the High Court, B. special control exercised by the Chief Justice of India, C. discretionary power of the Governor of the state, D. special powers provided to the Chief Minister of this regard. So if you see here, the Chief Justice of the High Court, he will be having two roles. What are they? One is the judiciary role, the other one is administrative role. Judiciary role is nothing but as a judge. He'll be sitting as a judge, he'll be exercising his judicial powers. So, this is a judicial role, simple, you know that. He also has the administrative powers. For example, in one of the previous question, we talked about this. These Chief Justice of High Court or Supreme Court, they have the power to appoint the officers, judicial officers, or the servants of that particular court. So, these things come under the administrative works of the administrative roles of the Chief Justice. Okay, so the Chief Justice of a High Court has two two roles. One is a judicial role, we know that. The other one is administrative role. So now in the question, they are asking whenever the Chief Justice of High Court acts in a administrative capacity, that is, whenever the Chief Justice of High Court is acting in an administrative role, then what will follow? So option A says that the writ jurisdiction of any other judges of the High Court. Is it true? He is subject to the writ jurisdiction of any other judges of the High Court. This is true. Let us say when he is exercising a administrative role. Let's say he is appointing some person, a servant of the High Court, or he is doing some other administrative work. In that case also, he cannot act arbitrarily. है ना? He cannot act arbitrarily. He cannot act inappropriately. He should follow certain rules and regulations. He cannot act on its own, on its arbitrarily. Okay. So whenever the the Chief Justice of a High Court acts arbitrarily, he is subject to the writ jurisdiction of the High Court. Okay, from another judge. Now the thing is, you might have listened to this, right? There are some writ jurisdiction. Okay, it will be imposed on certain authorities. Okay, sometimes the courts, sometimes the government authorities, sometimes on the legislative action, sometimes on the executive actions. So here in the judicial matter, if you see, okay, not just the subordinate courts or the subordinate judges, even the Chief Justice of the High Court, while exercising his administrative role, if he is acting arbitrarily, the writ jurisdiction will be exercised on him by another judge of the High Court. Not necessarily this is the Chief Justice of High Court. There will be another judges also in the High Court, right? So another judge of the High Court, same High Court, he'll be exercising a writ jurisdiction over the Chief Justice of this particular High Court. So answer A is the correct answer. Okay, then see here, Chief Justice dual role. So he has a dual role, as I already told you. One is judicial role. What is this? What is this judicial role? They preside over the cases and deliver judgments along with other judges. Okay, this is judicial role. Then he will be exercising a administrative role. What are these administrative roles? They oversee the administrative functioning of the High Court. Let us say the functioning of the High Court. He'll be overseeing the functioning of the High Court because he is the highest authority, right? And including staff assignment, budget allocation, and procedural matters. Okay, apart from appointment, he has many other administrative works. And during this administrative work, if he is acting arbitrarily or inappropriately, then this writ jurisdiction will be imposed on him, on the Chief Justice of the High Court by other judges. You can see here, obviously in High Courts there will be the Chief Justice of High Court plus other judges of the High Court. So other judges will be imposing the writ jurisdiction over the Chief Justice of the High Court. Okay. So the writ jurisdiction extends to any administrative decision deemed to be arbitrary, unreasonable, and exceeding legal authority. He should act within the legal authority. He cannot act arbitrarily, right? Then This includes the action taken by the Chief Justice in their administrative capacity. So, checks and balances. So, why this mechanism is given? This mechanism ensures that even the Chief Justice of the High Court, he cannot escape. Okay, he, while doing the administrative actions, he is, he should be put in the scrutiny. He cannot escape the scrutiny. Otherwise, what will happen? He'll be acting arbitrarily, right? If there is no checks and balance. So, any judge within the High Court can use their writ jurisdiction challenge decision to believe they are inappropriate. So, any judge, apart from the Chief Justice of an High Court, there will be other judges. Other judges. So, any judge, he can exercise his writ jurisdiction to scrutinize this Chief Justice of High Court when he is acting arbitrarily, unreasonably, or he is going beyond his authority. Okay, he has certain legal authority, he cannot go beyond the legal authority. Okay, while doing the administrative role. Next question. According to the Constitution of India, the term district judge shall not include option A, Chief Presidency Magistrate, option B, Sessions Judge, option C, Tribunal Judge, option D, Chief Judge of a Small Cause Court. So technically, they are asking about, according to the Constitution of India, the term district judge shall not include. So here the answer is option C, Tribunal Judge. So these tribunals are set up for resolving certain issues. Let's say administrative tribunal, environmental tribunal. There are certain areas. Okay, these tribunals are set up for over the jurisdiction of certain areas, and these tribunal judges are not actually included in the district judge. Okay, so the answer is option C. Technically, if you see, even the chief presidency magistrate and the chief judge of small court, they also are not considered as the chief, as the district judge. Technically speaking, only the sessions judge, we already saw, right? Sessions judge, he'll be the judge of a district court, the district level criminal court. So only B is the correct answer. But technically, sometimes UPSC asks these type of question. You should go for this absolute answer. This is not even possible. So option C is the correct answer, and you cannot waste time in trying to understand all these. Okay, and this question was like asked in 1996. So let us leave this thing. Answer is option C according to the official answer key. Okay, and technically these two also does not come under the district judge. Okay, so that's all. So I'll see you in the next class, students. Take care. Thank you.